us. Welcome to the session. We have lost a bit of time, and I will chair until such time that Manfred is available. And of course, yes, it is true that all of us decided to have the session together. There's so much happening in this space of, you know, the informal work context outside the employment, normal formal employment relationship, that we have thought to bring this panel together for purposes of the Biagi conference of this year. The three of us who are presenting actually also, you know, have been co-authors of a book that was published about 2 years ago on social security outside the realm of the employment contract. It's just one of many recent publications that have seen the light. There are several new ILO publications, very recent UNDP African publication. So we are all privileged to have increasingly this body of knowledge that we can rely on. What we have done for purposes of the session to bring three perspectives together, I'm going to ask presenters, as they will be presenting, to introduce themselves. But apart from myself, my topic to be exact will be organizing social protection for categories of workers falling outside the employment relationship. You know, lessons from the global north and global south. And mine will be particularly, you know, linked to the developing world context. However, we have Annamaria with us as well, Annamaria Westregård, and I would ask her to introduce herself as well. But first on the program, I believe, is Avinash Govindjee, and Avinash will talk about vulnerable transportation network company drivers in South Africa, social protection response. Thereafter, Annamaria on social labor protection for workers outside the traditional employment contract, a Swedish example. So can I first ask Avinash and Annamaria to introduce themselves, please? Thank you.
Thank you. Good afternoon, everybody. I'm Avinash Govindjee. I'm the Executive Dean at the Faculty of Law at Nelson Mandela University in Port Elizabeth, South Africa. It's a great pleasure to be with you this evening. Hi.
Annamaria, from your side, please.
Good afternoon. My name is Annamaria Westregård. I'm an Associated Professor in Labour Law and Social Security at the Department of Business Law at the University of Lund. I'm very happy to be here, though only in cyberspace.
Yes, thank you so much to both of you. I'm Marius Olivier, and I am, well, I'm attached to a few universities in an ad hoc position, or having an ad hoc position. For the rest, I'm doing social policy development work. So without further ado, let me ask Avinash then to address us on the topic of vulnerable transportation network company drivers in South Africa, a social protection response. And Avinash, maximum 10 minutes, if we maybe can cut it a minute or two shorter since we have lost so much time now.
Yes.
Thank you, Avinash. All over to you.
Thank you. Yes, it's a great pleasure to be with you this evening. As I said, it's a pity we can't, of course, be together. My thoughts are certainly with the people of Italy and with Modena, and of course we commemorate and remember the work of Marco Biagi appearing this evening. So this presentation was based and inspired by a case that was heard in South Africa in respect of the Uber drivers, so to say, and I started thinking a little bit about this and thought that the concept of vulnerability might be quite important when determining what the correct legal approach is. Now, one of the issues that arises is whether the drivers earn below a threshold. You can debate what the threshold is. In South Africa, we have a threshold which is
Can you hear Avinash? Is there a connection problem somewhere?
Oh, Can you hear me now, Marius?
I believe so, yes. Please,
Okay.
Please go ahead.
Thank you. Yes, so I'd like to look at the issue of vulnerability in relation to transportation network drivers. And there's a threshold in South African law that is set at approximately $13,500 US. That's used for different purposes. Now, I want to link that particular threshold and ask the question, should these drivers really be employees? And in the event that one concludes for various reasons that they are not properly defined as employees in South African law, nevertheless, what forms of social protection should be available to them? And I want to suggest that there has been an overemphasis, at least in our context, on fitting these drivers into the statutory definition of employee, and there's been an underemphasis of instead looking at the social protection position of the position, whether or not they are in fact categorized as employees. And perhaps inspired by the fact that we are talking about drivers and cars, I want to borrow from the concept of a hybrid. Like you get hybrid vehicles, I want to suggest that there's perhaps room for a hybrid approach that might consider these transportation network company or TNC drivers as being better described as independent workers, but with social protection for those that are in fact vulnerable, and that there would need to be flexibility when it comes to the context of social security in order to achieve that in reality. So there has been a case in South Africa. There is a judgment of the Labour Court. I spent a lot of time discussing that with you. The dominant impression test was applied in that case, just as you would with any debates about independent contractors versus employees. Uber took a jurisdictional point to say that on their own version, the drivers had failed to prove that there was an employment relationship with Uber South Africa. Any relationship would have been with Uber BV, which is a company operating out of the Netherlands. And of course, that decision, and I'm mindful of recent global developments, that decision has met with academic criticism, as you can imagine. Now, many people know that the South African constitutional framework is particularly strong. Everyone has the right to fair labor practices, a right to access social security. Every citizen has a right to choose their trade, occupation, or profession freely. And there's the right to freedom of association. My apologies. If I can just ask everybody to mute their microphone. We are getting some noise through the microphone of pages turning. So only employees have recourse to the dispute resolution provisions of the Labour Relations Act. And there's a wide definition of employee, which serves as the gateway to employment protection and social security. So we have a major issue in our statutory scheme, this distinction, as in many other parts of the world, between employees and independent contractors. And the legislature, to try to deal with that, introduced a presumption, a statutory presumption in 2002, which applies to people or persons that earn underneath that 13,500 approximate US dollar threshold. And if you do earn underneath that amount, you're presumed, regardless of the form of the contract, to be an employee if one of a range of factors are present. For example, if you only work for one employer, or if that employer provides you with the tools of your trade. And there are also guidelines that have been issued on who is an employee in South African law. And there's an attempt on the part of South Africa to accord with the ILO's employment relationship recommendation. Now, I've noted as part of my paper, various instruments and developments in formulating these arguments. I've considered the ILO Declaration on Social Justice for Fair Globalization, the Social Security Minimum Standards Convention, the Income Security Recommendation, of course, the Social Protection Floors Recommendation, and I've noted the global foreign law developments. TNC drivers have been recognized as workers who are entitled to a national minimum wage. I saw even yesterday there are significant developments, a realization in parts of the world that they should be entitled to leave benefits and the like. And there are judgments holding TNC drivers to presumptively be employees in the United States. There are also some interesting social protection developments in many countries, although they don't often get the same mileage as the big sort of catch-all question of are they employees or not. So in South America, for example, the way I understand it, in relation to universal pension schemes in Uruguay, my understanding is that the government has permitted these transportation network companies to operate in the country on condition that they do ensure mandatory social security coverage for all drivers. So what is then the legal position in South Africa? Well, I argue that the starting point needs to be the contract. That is and must remain relevant. It cannot simply be discarded. After one considers the contract, then indeed the vulnerability of the worker should take center stage. And in South Africa, I argue that there is a basis for which one can assess vulnerability, and that's by linking the earnings of the drivers to the threshold that appears in the statutory scheme, where workers earn or drivers earn above the threshold and they've consciously and deliberately agreed to structure a working relationship as one that is not a standard form employment, and provided there's a relatively equal bargaining position and the agreement is not a sham, well then arguably the classification of the relationship contained in the contract would be binding. In each case, there has to be a binding contract with the other party, and that was the main problem in the South African Uber case. The party cited in that case was Uber South Africa, and yet the court found that the claim in fact was against Uber BV, so to say. So importantly in this case, it does seem to have been agreed by the parties that the workers earned above the threshold that I mentioned, and the position would arguably be different on my take if it turned out that a particular driver earned underneath the threshold and was therefore vulnerable. So I want to move to the second leg of the argument and then move towards conclusion. And that is that let's assume for argument's sake that at least in South Africa for now, these drivers are not employees, perhaps based on the Labour Court decision that we have. What social protection intervention should be made available? Now remember, there's this constitutional framework, there are rights for everybody. They should be able to benefit from health and retirement benefits, compensation for work-related injuries, occupational health and safety, and not to be subjected to unfair discrimination. And the good news is that the South African statutory scheme can be read and interpreted in such a way that there's a basic floor of public and private forms of social protection available. There's legislation dealing with unfair discrimination. Road accident legislation becomes important because we're talking about drivers. That legislation is already wide enough to grant protection. The new national health insurance scheme should include medical benefits for this group as well. So there is some scope in the existing legislative framework to offer these forms of social protection. It's also interesting that I hope I understand this correctly, that in India, it appears to be the case that companies might even be levied a tax in order to contribute to worker welfare funds. Now, that type of model I find quite interesting, and perhaps that's something that could be leveraged in order to ensure that there's some contribution on the part of global companies when it comes to these transportation network company drivers. And I argue that that should apply irrespective of whether there's a employment relationship in terms of the definition of an employee. So, and likewise, I also believe it's possible for freedom of association to be given effect through transportation network company driver associations, and those don't need to be dependent on whether or not the employment context has actually been established. So I argue then in conclusion that we have the possibility here of a true hybrid classification. Drivers who are not in an employment relationship necessarily at present, but one that should nonetheless ensure a basic level of social protection. And I conclude with what Fredman and DeToy have argued, that it is at least time to consider ways of transcending the binary divide and ensuring decent work in the labour market, irrespective of employment status. Thanks very much, Marius.
Thank you, Avinash. Much appreciated also for trying to stick to the time. Annamaria, now we would like to hear you on social and labour protection for workers outside the traditional employment contract, a Swedish example.
Yes, thank you, Marius. My paper here, and also the book chapter, was that a Swedish example, or from the global north and it's Sweden is representative for all the Nordic countries. And if you want to read more about the other Nordic countries, you can also see at the project Future of Work, to which I made a reference in my paper. So this is I think it's very important. Yesterday we talked about platform work and labor law, but it's also very anxious that we talk about platform work and precarious work and the social security, what will happen between the fragmentation parts of work. And that's what I'm focusing on in my paper. And also now, if we take it on a European law level, we have the Principle 12 in the European Pillar of Social Rights and a recommendation about social protection for workers and self-employed, where the European Union recommend minimum standard of social protection for both workers and employees and self-employed. And if we then go to Sweden and see how it's arranged in Sweden. In Sweden, employees and all employees and all self-employed are protected and are covered by the unemployment benefits, sickness and insurance benefits, parental allowance, and retirement and old age benefits. The social insurances are all mandatory except unemployment insurance. The aim is to construct not the same kind of protection and regulation for self-employed and employees, but a similar protection for both groups. And how do we finance that? Well, in Sweden, there are very little difference in the expenses for work when you think about taxes and social security, whether you have an employee or if you are self-employed. Both groups pay 32% of the payroll in social security fees. And so even if the remuneration could differ between a self-employed and employee, as the self-employed are not protected by minimum wages in collective agreements, still this part of 32% for the social security fee is always the same. So if you compare with Sweden, the difference, the cost for work is more or less the same. The big difference in Sweden, I think, is when you compare to self-employed in other European countries, because not all the European countries do have social security. And maybe we have to compare with special platform work where you can sit in every country. Some of them you can, of course, the Uber drivers, then you have to be in Sweden to drive the cars. And some work you can put it everywhere in Europe. And of course, then we will compete with the social security. And there is always this risk for forum shopping between different countries' system. So it's the competition is not necessarily only between the wages, but it could also be a competition with the cheaper social security system. Who pays for the social fees in Sweden? It's the employer who pays for the employees, and the genuine self-employed, they pay their own social security. But as the tax authority are very anxious to get social security for everyone, there's also a rule that they have a principal have to pay for self-employed if he works very independently compared to the principal. So in that way, a principal also have to pay for those called assignment worker, or someone who's not employed but don't have a company registered by himself. Then the principal or employer have to pay social security. So the tax authority don't miss anyone. What I've studied and write about in my paper is also in Sweden, the legislator tried to create parity between employees and self-employed, but that's not particularly easy, as the legal system in social security originally was created for employees working 100% between 8 o'clock to 8 o'clock in the morning to 5 o'clock in the afternoon. And that creates, of course, a lot of problem when adapting to other kind of workers and self-employed. And what if I could identify some problems, is the calculation of compensation. It's very difficult for workers with temporary employments to they are put in a disadvantage as they can't and find it difficult to demonstrate a continue of employment. Assignment workers, they are in the gray zone, somewhere in between employment and self-employment. In labor law, they are almost always employees, but in social security in Sweden, most of them are regarded as self-employed. And that gap in between is not particularly good for them. We want to create a neutrally among various kind of forms of how you have your business model in company. We have the solo traders, limited company, solo small closed companies, small limited companies with only one shareholder, and they are treated different by tradition, treated different in the social security system, which is not good because it's not the kind of business model you have chosen that should be depends if you are going to have social security if you become ill, for instance. And of course, then we have, though we have an efficient tax authority, we still have unreported incomes and the unofficial sector. And if you don't pay social security fee, then you won't have any social security benefits either. And that could be, it's difficult to tell how large that sector is. And then we have the collective agreements, which it's a lot of the benefits. In Sweden, the benefits is only up to 38,000 euro a year. And over that, you are not paid anything. It's the collective agreements that goes in and pay the wages up to 90% if you become ill and have a higher wage than that. Now we have some collective agreements for the ORA, for instance, for the platform workers, and that's a rather new phenomenon in Sweden. And it's very important that the collective covers also the precarious worker. And then we have inquiry now for new legislation to better cope up with the new kind of employment. But unfortunately, they didn't analyze enough, I think, those new problems with umbrella companies, platform workers, etc. The only good thing about that is that me and my research group, we have a lot of things to do now to analyze this. So there's still a lot of problems. So if I should conclude, I would like to say, after working with self-employed and employment and platform workers in a project the last 3 years and focusing in labor legislation, I think it's very anxious that we also fight this war against bad condition on two fronts, also at the social security perspective. I think that the labor legislation, it will take time before you can have coverage, and the fragmentation of work with very short work, period of work will stay for some time, and then it's particularly important to focus what happened in between. And we also have, you should also have in mind that if a legislator tries to create parity between self-employed and employed, it's difficult. There's a lot of problems that shows up after a while in practice. And that's what we are working with at the moment. And then we have this problem was addressed yesterday, the collective agreement for self-employed as well. Thank you.
Thank you, Annamaria.
Now I can speak. Now I hear you.
Oh, good.
Oh, wonderful,
good.
Manfred. So what we have done up to now is that Avinash has spoken as well as Annamaria, and now I have to speak. So you want
go
to
ahead,
take the chair?
and then I after you I come in. Okay.
Okay, good. Thank you. Colleagues, as I've said, my topic concerns social protection for workers beyond the employment relationship in the informal economy in the global south, with some reference to recent developments. This is a vast topic. The developments are increasingly evident and prevalent in all across the developing world, Latin America and large parts of Asia, and certainly in Africa too. Of course, we have to understand the size of the problem, which is also numerically an issue. 2 billion of the world's employment population aged 15 and above actually work informally, and most of them, of course, in the developing world, in the global south. They represent 61% of the global employment. But what we do find is that these workers are by and large mostly effectively excluded from social protection. social security coverage in particular, and the reason being that the mainstream contributory social insurance schemes are based primarily on the notion of an employer-employee relationship. So it assumes formal sector employment involvement, while the social assistance non-contributory regime usually would, at least in the developing world, would be restricted to certain categories of those who are poor. So there has been an attempt over the years to try and cover these people, but mostly what has happened is that this coverage was restricted to letting them pay a double contribution so that they could be covered in the under the contributory schemes, which of course for many would not be an option at all. There is of course a moral issue here that we suggest to you that concentrating attention on reforming that part of the social security system, which covers only a small part of the labor force active in the formal labor market at the expense of those involved in non-traditional work and in the informal economy, is, in my view, inherently unequal, as it directs the attention of government and other stakeholders away from a huge segment of the population with no or little social security coverage. So what are the comparative developments that we have seen? Let me try and deal with them very briefly. The paper sets us out in a bit more detail. We have seen attempts to conceptually, towards conceptual extension or expansion. For example, the development of a notion of informal or unorganized sector or unorganized economy, and the Indian legislation, also the more recent draft of the security code in India, legislation in Tanzania, trying to develop a definitional perspective on these workers with a view to make sure that they are covered as far as possible. But then we have seen a range of regulatory and institutional developments, if I could use that term. The first is to extend the reach of social assistance arrangements to cover workers in the informal economy. And by and large, especially in Latin America, this has been fairly evident and successful. The Bolsa Familia in Brazil, the Oportunidades scheme in Mexico, but even in South Africa, the social grants covering almost 1/3 of the South African population. And China itself has, come up with major extensions in this regard. The second main avenue in terms of institutional arrangement is extending existing schemes and even making participation compulsory. We see it in South Africa with the inclusion of domestic workers under unemployment insurance. Some Latin American examples, very interesting actually. And then as a third plank of development, so to say, is an attempt to look at the informal economy as a whole and see how protection can be, or coverage can be extended to the informal economy as a whole. We find it, for example, in the legal area, framework laws that have been designed, developed in India, as I said, even this more recent Social Security Code, with all kinds of definitions that would ensure, if I could use the term, total coverage. The same applies to Indonesia, 2004 law to that effect. But also still on embracing the informal economy as a whole, we have seen the extension of very comprehensive insurance arrangements, in particular health insurance, to the extent and to the effect that these schemes would then embrace also those who work in the informal economy. On the other hand, we have sector by sector approaches that have been developed. In India, we have this as well, the Indian welfare funds, to give one example, very significant comprehensive schemes for particular sectors, funded in a particular way, which we don't have time to discuss now. Tunisia and Africa, probably the front runner, also time-wise, dating back to the 1980s already, adopting a gradualist sector by sector extension. One group after the other has been successfully, mostly successfully included in specialized social security arrangements by adopting realistic income scales, for example. And then finally, in this regard, we have some mutuality-based arrangements. The most best known example is, of course, the SEWA, Self-Employed Women's Association framework in India, where SEWA, as as an organization representing these workers, but also operating as a trade union, has, very extensively provided for social protection for its own workers, so to say, a bottom-up approach. Importantly, almost through is to suggest to you that the one lesson that we do learn is that unless you extend protection to the informal economy as a whole, and you are able to do so by relying on your current system, you really have to look at a framework of coverage and support that would address the particular context of those who work in the informal economy. And that goes for a dedicated tailor-made contribution modalities. Firstly, secondly, adjusting the entitlement criteria to such an extent that you allow those who work in the informal economy to draw on their benefits even if they were not able to comply with lengthy contribution periods. But finally, importantly, also to ensure that that there are in place benefit options that would speak to these particular needs and contexts of those in the informal economy. Finally, there need to be supportive arrangements in place. The emphasis on proper consultative approaches involving high-level governmental institutions, so to say. Very often this has made the difference between a successful or not so successful extension of social security coverage to those in the informal economy. Proper communication with those affected, in fact, with the population as a whole, because this has is of national interest. And really, in the final instance, developing an enabling framework that would support and allow those in the informal economy to participate, and if they have to contribute, for example, incentives being provided or subsidies even provided by governments would be one of many examples of such an enabling framework. I thank you. Over to you, Manfred.
Okay, I apologize for having had enormous problems in connecting. Sorry. I am one of the friends of Marco Biagi, the ever smaller group. We have worked together for many years, and I'm very grateful to the foundation for continuing in further developing Marco's legacy, also by these kind of conferences. Well, I would make my comments, even if I have not heard two of the speeches, but I have read everything. So all I would say is the following. All three papers teach us that we have to give up traditional concepts and be cautious in falling into new traps. If I take Avinash's paper, it demonstrates that the demarcation lines between employees, independent workers, and self-employed are more or less arbitrary. The Uber debate is the best example of this dilemma. Therefore, instead of trying to establish new classifications and categorizations, a change of paradigm might be more helpful. Therefore, I repeat what I said already yesterday. Instead of putting workers in different categories, we should discuss the floor of rights, including social security, all the working people need, no matter what their status is. It focuses on protection of workers regardless of their contractual arrangement and of their employment status. The focus, as I said already yesterday, is on the protective umbrella. This, however, implies another problem. Who is responsible for providing the protection? The solution might be relatively easy in case of platform work, but it is certainly very difficult for other self-employed workers. As far as platform work, by the way, is concerned, we should not fall into the trap that platforms like Uber merely act as intermediaries. As the Court of Justice of the EU has made perfectly clear, Uber is not an intermediary, but a transport company. Again, we cannot simply accept the traditional definition of who is an employer. We instead have to enter the debate on the reconceptualization of this notion. There are lots of suggestions. Most appealing to me is Jeremy Brussels' suggestion for a functional concept of employer fitting better into the reality of platform economy and making it more difficult for platforms to escape their duties. Annamarie's paper shows us how important it is for vulnerable self-employed to be included into the collective bargaining system. And she refers to the CJEU's Kunstenjudgment as an obstacle for such an inclusion. Here again, we are confronted with a position which is to be reconceptualized. According to the Court of Justice of the EU, self-employed cannot be included in collective agreements because of the competition rules contained in the Treaty of the Functioning of the EU. This archaic and narrow-minded view of competition law, which is based on a reality of the past, has to be overcome. In addition, it should be kept in mind that according to the ILO Convention number 87 on freedom of association, also self-employed workers are fully covered. In Annamarie's paper, we not only can learn how important it is to get rid of outdated concepts, it also teaches us to be cautious in following problematic innovations. Such an innovation which hides the real facts and thereby is confusing our minds is the term collaborative economy. The economy is far away of a system of collaboration where platforms and workers have a comparable position and where they both profit in a similar way. Instead, it is an economy where the mechanisms of control are perhaps stronger than ever. Now, if you come to Marius' paper, we particularly learn how our traditional concepts are misleading. There is first the insight that the systems of and the challenges for developed countries and for countries with emerging economies are significantly different. This raises the question of what does this mean for one of the basic concepts underlying the work of the ILO, universality. It should be clear that this notion cannot be understood in an absolute sense, but that regionalization is to be stressed much more in the same time. There we also can learn that informal economy is by no means a homogeneous entity, but rather a set of working patterns of great variety, as it is the case within the so-called formal economy. This insight forces us to focus on the very specific conditions of each group if we want to develop solutions. In other words, the task is much more complex than we traditionally thought. Marius is also stressing the need of collective voice. And he makes perfectly clear that collective representation will have a different face compared to the traditional actors in the formal economy. The question then is what this means for the tripartite structure of the ILO if the focus more and more is also on the informal sector. Will this lead to a restructuring of the labor bench in Geneva? I doubt it, but I think it might be worthwhile to think about it. In short, and to make the point, the three papers not only provide a lot of useful information, but they also confront us with a very difficult questions for which we have not yet solutions. Thank you. And now we have time for questions and answers. Do we have already something on the chat? I have a look. Wait a second. I don't know why this doesn't work.
There is no question in the chat right now.
Yeah, there's no question. Are there any questions? You also can ask by raising the hand. You know, you see the sign for putting up your hand. Yeah. Barbara Grandi. Barbara Grandi has a question. Please, Barbara. Where is Barbara? Where is Barbara? It seems not to work. I'm so sorry. I don't know. Barbara is not speaking.
Maybe, Manfred, maybe you have to click on the hand to authorize her to speak. Click on the symbol of the hand.
I'm sorry. I'm sorry. I didn't know that. Does it work now, Barbara?
Just
Can you hear
Hello?
me now?
Yeah.
yes.
Yes, now we can hear you.
We can.
Go ahead.
Okay. Yeah. I was wondering whether, and I think that could be a main point for the purpose of the subject that today is being considered, whether the proposed directive for the minimum wage at the European level is to be considered and can be considered an important step also for the independent contractor and self-employment. Insofar, the directive is considering formally only the subordinated workers, but preliminary, I want to make the point that what is more what is more relevant is the social protection for these workers, and the minimum wage, although is considering the remuneration of work, should be considered a social protection nonetheless. So the directive is referring to only dependent workers, but at its final article, Article 11, it provides for a protection of workers who would be in a position to claim for their minimum wage, their right for a minimum wage, and I mean there is no point in avoiding that someone who has an independent contractor position could finally argue that in the end he is not actually independent contractor, but he's actually a dependent one. And in that case, it would turn that it would be upon the states to protect all these workers for their minimum social protection.
Of course, there are the social actors are yeah. So it was about the question that you made about who is going to pay for the social work, the social security of the precarious and self-employed.
Yes, thank you. Who wants to react? Marius, Avinash.
Maybe I could say something.
Oh,
Who
okay.
wants? Annamaria, go ahead.
I can start because as a European Union member, I can say I think you have to differ between wages and labor law and social protection. As maybe you know, Sweden and all the other Nordic countries, they say firmly no to this minimum wage directive. It's the government, the employers' organization, and the union. All the unions in Sweden, they are all together and really determined to say no to this directive, as it's a threat against the Swedish and the Nordic model of wage formation and how to organize work. So it's not a solution for the Nordic countries, and I think you have to separate minimum wages. That's one thing, and of course we have to guarantee also platform workers and precarious workers to have a guaranteed minimum wage, but social protection, and that the minimum wage is for the parties, the social parties, the union and the employer organization to decide about in collective agreement. But the social security in our countries is at state level in collective agreements, and it's the state who pays the social security. So that part of guarantee security is not, in some parts, the top level, but probably those precarious workers, they don't have a salary over 38,000 euro a year. So it's in our countries, it's the states who have to protect them with their how they are organized, the social security legislation.
Okay.
Yes.
Avinash?
Thanks, Manfred. It's an interesting notion because in South Africa, we actually have a national minimum wage act, but it ends up in a circular way coming back to the same problem, because on the one hand, it uses the notion of worker, which is broader than an employee. So from that perspective, you think, okay, it covers. I've been arguing, we can have a hybrid type of worker, but then what it does is it defines worker to mean any person who works for another, and then it takes us back into the debate as to whether the person is an employee or an independent contractor. So I think it's a very, very interesting notion to explore, but all I can say without knowing the European position is that the way in which it's actually crafted might take one back into the same problem that one was trying to use that to address. And then it boils down to, once again, first determining on the traditional tests, are we dealing with employees or independent contractors? Yeah.
Marius?
Yes, let me add that from the informal economy in the global south perspective, this is actually an interesting debate too. We find increasingly, at least a scientific discourse around the following, and in fact some state practice too, whereby the national minimum wage is being seen as a baseline, serving as a baseline for the calculation of contributions, even for, by, or on behalf of informal economy workers. So at least you have a standardized baseline. The example of Tunisia that I mentioned during my presentation is actually exactly that. So there is a minimum baseline, and you could then argue as an informal economy worker that in your particular case we need a baseline, but it has a significant value for strengthening the the contribution basis for those in informal economy. And let me just add finally that what we actually see is there are increasing examples in the developing world where governments come forward to play their part as well by providing subsidies or partial subsidies, partly as an incentive, of course, for those in the informal economy to participate in contributory schemes. And again, there the role of minimum wage would be quite relevant to determine what is you know, the framework for or the contribution basis which government should use, you know, for that purpose. Thank you.
Yes. Are there more questions? Yeah. No. No. I don't see any more questions. If that's the case, I would like to thank you, the speakers, and I would like to apologize again for having made such a mess, but it's my equipment here, apparently. It doesn't work. So I'm very sorry, you know. So we have a break. The break is until when?
4:15, Manfred. 4:15. 4:15.
4:15. We have already 4:06, so it's 9 minutes. Okay?
Okay.
So,
Thank you. Thank you.
Thank you, Manfred. Thank you.
Thank you.